In Georgia, parties can decide to get a divorce, and here's how it works. The first thing you have to do is get a petition and get the documentation necessary to serve the other party with your divorce complaint. Meaning, in Georgia, the way in which you get a divorce is you have to file paperwork with the courthouse. To be more specific, what actually happens in the process is the following. One, there has to be a complaint and summons drafted to give to the other side showing that you intend to get a divorce. A summons has the particularity, or a summons has the information about how they respond to the petition as the court requires. After the summons, you actually have the complaint. The complaint is the actual documentation or the actual document that's been filed with the court that signals to the other party that you want a divorce. In Georgia, state law allows for 13 reasons to get a divorce. The most common used one is irreconcilable differences. That's when the parties have decided that they don't want to be together and get a divorce. Once the complaint has been filed with the court and given to the other party for them to be served, the next thing that happens is that you have to wait for their response. If they do not respond within 30 days, a judge could grant the divorce on the 31st day. If they do respond in that amount of time, the thing that happens next is that you have to decide the route the case is going to take. If the parties are going to settle the divorce, which means you're going to file the appropriate paperwork together, and that allows the judge to give a final order, that's one path. Another path it can take is that if the parties decide they don't agree on certain matters, that's for the judge to decide. Georgia is also unique in this respect. In Georgia, you can have a judge trial or you can have a jury trial. The jury trial doesn't cover all matters, but it does cover most matters about asset division, meaning custody will always be left up to the judge to determine. It would not go to a jury. That's a unique fact about divorce in Georgia. If the parties do not agree on matters, you can have temporary hearings up until you get to a final hearing, or you can just have a final hearing. In these hearings, that's when the judge makes a determination about facts and next steps in the case. A judge will sign an order, and that order that's signed will be what the conduct and what should be happening between the parties. That order is enforceable under Georgia law. There can be a series of temporary hearings, and those temporary hearings can lead you to mediation, or you can mediate without having a temporary hearing. What mediation is where the parties get together and sit down and try to resolve all of their issues. A trained mediator is a person that the court has determined can help couples and parties work through the matter. A mediator is a person who the court assigns or who the parties can go to voluntarily to determine how to resolve their marriage. When you go to mediation, it is voluntary. What happens in mediation is the parties are led by a mediator to come up with a compromise on all issues that would resolve the marriage. That's child support, that could be custody, that could be assets, that could be debt, that could be alimony. All issues surrounding the couple will hopefully be decided in mediation. And if so, there'll be a joint agreement that the mediator would write up. And when the mediator writes that agreement up, that will be submitted to the court. It will be submitted to the court to become a final order. When that occurs, the parties can be divorced. Or if the parties are not agreeing, they can have a series of hearings and ultimately a final hearing, and the judge will decide all the matters between the parties. In Georgia, to be able to divide assets, the court uses what's called equitable division to make that determination. What equitable division is in Georgia is a judge making a determination from facts they're presented about what should be the separation of assets between parties. Many people know about community property states such as California, where in a community property state it's 50-50 split of all of the assets. However, that's not the case in Georgia. Georgia's an equitable division state, and in an equitable division state what happens is a judge that makes a determination of what is equitable between the parties. What that means is a judge, from hearing information from the parties, can make a determination as to what is equitable between the parties. Meaning, instead of 50-50, asset division could be 60-40, it could be 70-30, it could be 100%, 0%. That all depends on the facts that's given to the judge. The judge can make that determination, or there's a second way to be able to do that. That second way of doing that is going to a jury. Georgia is a jury trial state. So what that means is that they could be a jury of your peers who decide what the asset division should be. That would be anything related to property, that could be anything related to pensions, 401ks, major assets such as cars, houses, etc. That could be decided by a jury in Georgia, and you would get a jury verdict as to what each party gets. In Georgia, The equation for alimony is not scientific at all. It is simply this: the demonstrated need versus the other person's ability to pay. The person's demonstrated need who's requesting it, and the other party who supposedly has the money, their ability to pay. And so you may ask, what happens in a determination like this? And that's up to the court to decide. But it can be based on the income disparities between the party. It can be based on an agreement that the parties may have made about what the incomes would be. It can be based on a variety of factors. But demonstrated need must be something that's tangible. I need $1,500 more a month to be able to live in an apartment or a house. The other party has $1,500 a month that they can pay to the party who needs it. At that point, that would be eligible for alimony. The best way to think about alimony is this way: does the party requesting it actually need it, and can the other party pay it? So what that means is the party who can pay alimony, after they are able to live and provide for themselves, do they have enough excess money that they would be able to pay to the other side for the other side to live? And that's how you determine alimony. In Georgia, most alimony is determined after 10 years. Most judges look at alimony as something that you'd be eligible for after 10 years. That's not to say that people don't get alimony after having been married a couple of years, but most times alimony judges don't put on the table until 10 years. If alimony has been granted to a person, they could have permanent alimony or they could have conditions that end alimony. And so permanent alimony would be, just like it implies, for the rest of your life. However, alimony that's not permanent could be alimony that terminates after a person gets married or after 5 years, etc. Divorce can be a tough process. Alimony in divorce can be even tougher. If you need any help, don't hesitate to give us a call.